So it's taken about 13 years, but Western Cape Judge President John Hlophe, accused of interfering and trying to influence two Constitutional Court judges, has now been found guilty of gross misconduct. In 2008, Hlophe had approached both Justices Chris Jafta and Besin Kabinde about the case before them relating to former President Jacob Zuma, judgment of which had at that time been reserved. It's taken a very long time, but he has now been found to have breached Section 165 of the Constitution for attempting to influence two Constitutional Court justices to violate their oaths of office. But it's not quite over. The Judicial Services Commission must decide if it agrees with the tribunal's decision. If it does, the matter will go to the National Assembly, where a two-thirds majority vote will be needed to impeach him. Let's discuss this now with Nicole Fritz of Freedom Under Law. Good evening. Thank you very much for your time. So there's still some way to go. How long do you think before this matter is going to be resolved?
Good evening, Sally. And I wish I could give you a short, sharp answer to that. I mean, as you've already indicated, it's taken us 13 years to get to this point. We can only pray that it's not going to take us anywhere near that length of time for it to reach its ultimate conclusion. There has to be, as you said, deliberations by the Judicial Service Commission as a body in its entirety in respect of the report that has now come down from the Judicial Conduct Tribunal. If they endorse those findings of the report and hold that Judge President John Hlophe must be held to have breached his oath of office, have committed gross misconduct, then the National Assembly will have to call for his removal, and that will have to happen by a vote of two-thirds. And at this point, I'm afraid I can't even venture a guess as to how long and whether there will be any delays, if there will be any attempts to review decisions on the part of Judge President Hlophe. That I can't say.
All right, so 13 years and counting. I'm wondering if any of the cases that he's presided over since this inquiry was first lodged could now be vulnerable to challenge or review. And I'm thinking specifically of his recent one in the Bongani Bongo case.
No, I don't. We'll have to see. I think it would require, very clear evidence that there was specific bias shown in that particular matter. I mean, obviously, we're hoping in respect to that matter that there will be a review on the part of the National Prosecuting Authority that bodies, if they believe that the judgment is one which is not reflective of justice and justice handed down in a manner that is free and fair, that they seek to use avenues of appeal or review. But I don't think it, even if he is found ultimately by the JSC to be guilty of gross misconduct and to be then impeached and removed, that would then open up for review any decisions. That would just introduce such uncertainty into the legal system. And obviously there are parties and litigants who have now sort of rested and sought to exercise their lives there, on the basis of those judgments. So it would introduce enormous uncertainty.
Does he continue as Judge President for now?
Well, that is something that we will need to see. It's certainly Freedom Under Law's position that he should now be suspended. That is not a determination of guilt. It's really a question of seeking to balance the interests here. And the fact is that the public must be able to have confidence in the administration of justice. It's not now just an allegation against the Judge President of the Western Cape High Court. It is that a Judicial Conduct Tribunal has found that he did breach his oath of office, that he should be found guilty of gross misconduct. And the Constitution provides and legislation provides that it is in the power of the Judicial Service Commission to recommend to the President that when a judge is the subject of such a procedure, that he of the complaint until that comes to a conclusion. And as I said, we think that it's very important that he be suspended until the conclusion of this complaint so that the public can have faith in the administration of justice.
So in his defence, Judge President John Hlophe said he didn't think there was anything untoward in speaking to these two Constitutional Court judges. Explain to us, because it seems that he says judges talk to each other all the time, but there are very clear limitations on that. So if you could just briefly explain what those limitations are and whether you think it's plausible that he didn't know about those limitations.
Well, the Judicial Conduct Tribunal's report makes it pretty clear that it would be implausible for him to be of that view. Given the number of years he had served as a judge at the point at which he made these approaches. They also say that various opportunities arose during these very lengthy procedures, this very lengthy process, for him to test the points, the statements that were made that in fact it is entirely improper for that type of approach to be made, and he did not. He did not subject such statements to cross-examination. So the tribunal's report very much says that they believe that he was, in fact, of the view he understood the position. But they also say, objectively, as a judicial officer, it is a well-known principle that whilst you might discuss cases, judges might discuss cases, you do not, as a judge, discuss a matter that is pending with a judge who is on the panel and when you are not yourself on that panel. And that is a very clear principle, and that is to insulate judges, to ensure that there is no influence brought to bear, that they are able to deliberate and they are able to apply a mind that is absolutely free and without favour when they make their determinations, and that is what justice requires.
Well, thank you so much, Nicole Fritz of Freedom Under Law. And of course, John Hlophe also saying that late Chief Justice Pius Lange and Judge Dikgang Moseneke had targeted him politically. Those claims were dismissed by the tribunal.